first panel today is CARES Act Litigation, moderated by Amy Spivey. Proceed with the panel.
Good morning, everyone. Thanks for joining us. I'm really excited about this panel. We have a lot to cover, so I'm going to keep the introductions brief. My name is Amy Spivey. I am a visiting assistant professor and the director of the UC Hastings Low Income Taxpayer Clinic. With us today, we have Les Book, who's a professor of law at Villanova Law School, Jen Burdick, who's the supervising attorney, Community Legal Services of Philadelphia, Robert Friedman, who is senior counsel at the Institute for Constitutional Advocacy and Protection in Washington, D.C., Nina Olson, who's the executive director for the Center of Taxpayer Rights and our previous national taxpayer advocate, and Yaman Salahi, who's a partner at Leif Cabraser. Let's go to the next slide, and Nina, I'll lead it over to you.
Thanks so much, Amy. So the purpose of this panel is to learn about the ongoing litigation that is arising from the CARES Act economic impact payment provisions. And what we hope to do is identify some areas in which there is high impact tax litigation, and that would include procedural issues, certain causes of action, appropriate relief that you can request through litigation, how you choose plaintiffs, and most interestingly for the tax lawyers here, partnering with non-tax attorneys, because they can definitely bring really interesting observations of how all of the above issues have played out in areas of law other than taxation. So it puts tax exceptionalism squarely into the focus. And before I start with just setting the stage with what the economic impact payments are and then turn it over to the rest of the panelists, I thought I would just explain sort of why I'm here and the role of the Center for Taxpayer Rights. When I retired as the National Taxpayer Advocate, and I immediately established the Center for Taxpayer Rights, and one of the things that we wanted to do was create a low-income taxpayer clinic support center. And part of the goal of that was to create some kind of entity that could get the clinics to begin to think about issues in a coordinated way. And that would include coordinating litigation and coordinating litigation strategy. And so one of the first things that we did was create an advisory board. I mean, members of this panel are actually on the advisory board. And then second, to establish, once the CARES Act had been enacted, I recognized, many of us recognized early on, that there were some litigation opportunities. And so the center is hosting and has established a litigation strategy call, a weekly call, in which we have discussed the issues that you're going to hear discussed today, and from which, or as part of which, many of the pieces of the litigation efforts have been partnered with, we have assisted in various ways, and the information has been shared among the clinics that participate in that call. And that's all to creating an environment where the clinics are actually being able to act with the same kind of coordination, for example, that chief counsel attorneys do within the IRS, and have access to information about what is going on outside among other clinics, so that we can share that and really present issues to the court and square them up in a coordinated fashion. So having said that, let me go on to just setting the stage for the CARES Act and the economic impact payments. So the CARES Act provides for what we call EIPs, economic impact payments, in the amounts up to $1,200 per person, $2,400 for married couples, and $500 for each qualifying child. There is an income cap, where it phases out completely and where it starts phasing out. And the Act is structured in a way similar to the 2008 and 2009 payments that occurred during the Great Recession. It's in the form of a refundable credit that is claimed on the 2020 tax return, but there is an advanced payment of the economic impact payment that is made in 2020 based on first your 2019 tax return, and if no 2019 tax return has been filed because, of course, the IRS was shut down, for the most part during some critical time in the 2020 filing season, and the 2019 filing deadline was pushed back to July 15th. If there's no 2019 on file when at the time the IRS is making the advanced payment, then it will look to the 2018 return. And then the next issue is that the law provides that no return is necessary for certain recipients. So recipients who have the law specifically says that if there is no return filed on 2019 or 2018, then the IRS is to look to see whether there is information based on the Social Security 1099 forms or the Railroad Retirement Benefit 1099 forms, in which case the IRS was to work with Social Security to make sure that you could get payments through those folks' normal payment method of getting Social Security or Railroad Retirement benefits. And the IRS also then went on and worked with Veterans Administration. So basically, recipients of Social Security, retirement benefits, disability benefits, supplemental security income, railroad retirement benefits, and certain veterans benefits, if they do not otherwise have a return on file, they would get automatic payments. However, since there are still a whole bunch of people that have no return filing requirement because their income is below return filing threshold, commendably, the IRS set up a non-filer portal, which was an easy way to add to enter into the system, the filing system, to get your $1,200 or $2,400 payment. And you could also add, even if you were one of those category of automatic payments, Social Security, et cetera, you could use the non-filer portal to enter your children so that you could get your dependent payments. Now, importantly, these advance payments are not subject to offset, and that's different from 2008. 2008, they were subject to offset for your past tax debts as well as many other issues. For the 2020 payments, they are only subject to offset for child support. The IRS also made a provision, since there were so many people unbanked and they didn't have financial information for some of these folks. It was normally looking at your last filed return, and if you were getting a refund and you had designated direct deposit, it would use that information. It had also created an application that people could go in and file, provide their updated account information. Sometimes that didn't work. It crossed in the mail, so to speak. But the IRS, in addition to making direct deposits, would issue it based on paper checks if that's what the person had done in the past for refunds. And then for a particular group of people, later in the process, Treasury contracted with a private bank and created debit cards. There was some confusion about the debit cards because they were initially sent out in blank paper envelopes, and people threw them away because they thought it was junk mail. But that is being corrected. The next round is being sent out with IRS address. They still may throw it away, but you can try. Most importantly, I think for all of the litigation that we're going to discuss going forward, is the fact that the law provides, as with 2008, the payments that were made in 2008, that no refund or credit shall be made or allowed after December 31st, 2020. That will come up in a bunch of the litigation. So then, just to frame things before I turn it over to Les to talk, it's a good thing to take a moment to think about what we are really seeing here with the CARES Act litigation. And it really is sort of a continuing path of how Congress has chosen to use the IRS. I think it has, despite, fumbles and difficulties and things like that, the IRS is certainly the one part in the federal government that actually can get things like moving massive amounts of money quickly done. And when you contrast the IRS's mission statement, provide America's taxpayers top quality service by helping them understand and meet their tax responsibilities, and enforce the law with integrity and fairness to all. And I will take a moment to do my constant editorial comment, which is, in the dark of night, the IRS changed that last clause from and comply and administer the law with integrity and fairness to all to enforce the law. And I cannot tell you how important that change of language is and how troubling it is to me as someone who's an advocate for taxpayer rights. But one thing that you will see is that it really looks at the role of the IRS mission in the context of a revenue collection agency, rather than as part of the federal safety net and a benefits administrator. And I think that you see this, not only with the Earned Income Credit, but with the Affordable Care Act, the premium tax credits and the advanced premium tax credits, that increasingly the IRS is viewed as an entity that not only collects revenue, but also delivers benefits. And we see that no more obviously, than here with the economic impact payment, which is such a key mover in keeping people out of total economic disaster during this pandemic. So now I'm going to turn it over to Les to take it away.
Thanks so much, Nina, and thanks, Amy, for putting this together. And we're obviously in a very unusual time in many so many ways. And I think on a micro level on this panel, I think Rob, Yuman, and Jen, I don't think a year ago you would have thought you'd be at an ABA tax section meeting. Constitutional lawyers, class action litigators, benefits attorneys. It's typically not where you find yourself at an ABA tax section fall meeting, and certainly not in a virtual meeting. But the notion of using the tax system to deliver benefits that Nina mentioned in setting the context is really kind of runs counter to, in some ways, some of the longstanding principles that have been kind of at the foundation of our tax system, of our modern tax system, which has been essentially one that has protected the tax system from many of the kinds of procedural challenges that are endemic in other areas of the law. So when people talk of tax exceptionalism, it means different things to different people, but at a kind of a pretty broad level, it really means a sense that the tax system is different or special, such that general legal principles, constitutional law principles, administrative law principles either do not apply or apply in a very different way than they do in other areas. And that has been, as many of us know, that has been slowly receding in time in over the last decade, especially as things have accelerated, as courts and academics have really been kind of really thinking about ways in which the tax system should be and could be kind of improved by norms and principles that apply in other areas. So there are a number of different bulwarks or defenses that have arisen to protect the tax system from early challenges to either a statute or to the way that the IRS administers a statute, including the Anti-Injunction Act, which has generally pushed litigants to traditional enforcement proceedings, whether it be a deficiency case or a refund case, if there is an issue with either the way in which the IRS has promulgated guidance with respect to a substantive provision, or actually the constitutional adequacy of a statutory provision that's embedded in Title 26. So we have this kind of background of kind of tax exceptionalism. But there is, as I've mentioned, as we move on to the next slide, the sense that really the current process is inadequate. And we think about how the current process overlays with the CARES mechanism. We see that typically in order to challenge one's entitlement to a refund, right? We most of us know that there is a process that one goes through, filing a refund claim, and either having the claim denied, or after 6 months elapse, you can file a refund suit, assuming the full payment has been made, in district court or court of federal claims. We can see, however, how the requirement of exhaustion really runs counter in many ways to some of the the important concerns that Congress expressed in CARES, which was to get money out and get money out quickly. So if there are challenges to either the constitutional adequacy of the statute or the way in which the IRS is administering the provision, that really this traditional tax refund mechanism is in many ways inadequate. And as Rob is going to discuss, one of the issues involves kind of equal protection analysis. There's due process concerns, which we'll get into. So there is this sense that especially for those who are not kind of embedded in the tax law, like Rob and Yaman and Jen, that hey, wait a second, we need to think about ways in which we can get courts to consider the adequacy of what Congress has done or what the IRS is doing. So, as we move on to the next slide quickly, I'll just mention that this has been a long-standing kind of the courts have been really thinking about ways in which to open the door in different select ways, and we could spend a lot of time on some of the complex cases that have arisen. One of the more important cases, which I'll just mention, is from about a decade ago, the Cohen case, which involved a challenge to the IRS's creation of a separate mechanism to refund a telephone excise tax, and in that case, there was a longstanding litigation and the courts allowed a claim under the Administrative Procedure Act to challenge the IRS's promulgation of a notice that allowed for the challenge of the refund of a telephone excise tax. And there was a really interesting and important kind of analysis as to whether the APA would allow a challenge, or whether the Anti-Injunction Act should prevent a challenge to the mechanism or the manner in which the IRS was allowing for refund claims. And in that case, the D.C. Circuit noted that while normally sovereign immunity and the normal approach to challenging tax cases requires a refund suit, but when there is a challenge that is really not going towards the actual, that looks to things like the way in which the IRS is administering a provision or the process that it's using, the D.C. Circuit opened up the door to allow for an APA challenge as well as an exception to the Anti-Injunction Act, and that really kind of fits in nicely with some of the challenges in specific cases that we're going to discuss in the rest of the panel. So with that, I'll turn it over to Rob, who will talk about a specific challenge involving constitutional equal protection challenges to the CARE statute.
Thanks, Les. You're correct that I did not anticipate being a part of this panel last year, but I'm happy to be. These are important issues, and I'm excited to be part of the discussion. So I, as Les mentioned, am going to be talking about some of the pending litigation challenging certain components of the CARES Act. And I will first provide an overview of the discrimination or denial of payments to undocumented immigrants and their families and how that works. I'll then give an overview of the legal theories underlying the pending cases, and then give an update on the status of the litigation. So next slide, please. Thanks. So the economic impact payments, as I'm sure many are familiar with, require a tax filer to have a social security number in order to receive a distribution. And what that means in practice is that undocumented immigrants who use individual taxpayer identification numbers, or ITINs, and are categorically barred from using social security numbers or receiving social security numbers are excluded from the EIP program. That adds up to about 10 million different tax filers who pay billions in dollars taxes each year. But it also extends beyond the taxpayer to their family members, including U.S. citizen family members and legal permanent resident or green card holder family members. So for spouses, that adds up to about 1.7 million spouses who would normally qualify and satisfy all the statutory requirements for an economic impact payment. There are two exceptions that I'll flag there. One is that if either spouse is in the military, then both can get an economic impact payment regardless of whether one uses an ITIN. And the other is that the spousal exclusion only applies if the two partners use the filing status of married filing jointly. So the U.S. citizen or legal permanent resident could choose to file their taxes separately, but as I'm sure you're all familiar with, that carries its own financial burdens, which might undermine or completely eliminate the benefit of the economic impact payment. And it's also worth noting that for those who had already filed their taxes by the time the CARES Act was passed, under the status married filing jointly, the option of filing a superseding return to get an economic impact payment this year will not work, or at least that's our understanding, that the IRS is not distributing EIPs based on superseding returns. So that means a year of delay, and a year of delay when you're talking about emergency assistance is obviously problematic. It also, the exclusion of people who do not have Social Security numbers negatively affects approximately 4 million U.S. citizen children of either one or two undocumented parents, or of mixed status parents, one who's undocumented and one who is a citizen. Next slide, please. And it's worth noting that this exclusion hits a particularly vulnerable group at a particularly vulnerable time. I mean, I think we're all familiar with the challenges that this population faces, but they are exacerbated right now. Undocumented immigrants tend to work in industries that have been hardest hit by the pandemic. So restaurants, retail, residential construction, those are all areas where job loss is high, and so the need for assistance is high as well. They also cannot seek unemployment benefits as a general matter. That included the CARES Act expansion of unemployment benefits when it was in effect. And if there should be a second round of legislation, I'm sure that they'll be excluded from that as well. They're often ineligible for local aid, though there are some exceptions depending on how different municipalities structure their aid. And they even have limited access to private credit, both in terms of credit cards and even some payday loans. So the economic impact payments really could have provided a much needed lifeline to these populations. And I want to flag that the denial of even that portion that is earmarked for children. So, if you have a qualifying child, you can get an additional economic impact payment of up to $500. Even the exclusion of that is unusual in the distribution of federal assistance. A number of other programs allow aid to flow to children, even if the parent is undocumented. That includes Supplemental Nutrition Assistance Program, what we refer to as food stamps, TANF, what we refer to as welfare, the child tax credit. Really the only program that has this similar exclusion, even of the U.S. citizen child, that we're aware of is the Earned Income Tax Credit. And obviously that stands on somewhat different footing in that it's trying to incentivize work in the tax filer. Okay, so moving on to the legal challenges. There are a number of them, and they tend to fall into two different buckets. The first is challenges brought by U.S. citizens or legal permanent residents to the exclusion based on the spouse's lack of a Social Security number, or, as framed by the plaintiffs, undocumented status. I've listed most of the cases in the slide, and I'll flag the Doe versus Trump case out of the Central District of California, and the Amador case, which is out of the District of Maryland, and I'll return to those two because there have been decisions in those cases. And each of these cases raises three basic claims. One is that the denial of economic impact payments to both partners based on the status of one partner burdens the fundamental right to marriage. Then there's a closely related claim that denying an economic impact payment to the U.S. citizen based on the immigration status of the partner violates equal protection principles. And then they've also brought First Amendment claims. And there are two components to that. One is that selecting the status married filing jointly itself carries an expressive message. And so forcing or incentivizing them to elect married filing separately burdens their right to expression. And also, and this starts to resemble the marriage claim, that it burdens their right to associate with their partner. And in each of these cases, the remedy that they've requested is an injunction or a declaratory judgment, and that'll become relevant a little bit later when I try and run through the issue of sovereign immunity. Then in the second bucket is just one case. It's the one that Les and I are working on, and it's on behalf of U.S. citizen children. And it also brings an equal protection claim, and only an equal protection claim. And the theory there is that you cannot discriminate against citizen children, here the discrimination being the denial of the benefits of economic impact payments based on the immigration status of their parents. And there are some cases applying that principle with respect to state action, and also it resembles what you may be familiar with in now is not as common, but the denial of benefits to children who were born out of wedlock based on their parents' marital status. Next slide, please. So there are three disputed issues across each case. One, and this kind of gets into the tax exceptionalism area that Les flagged. So one is, do the plaintiffs have standing? Do they have an injury, in fact, that allows them to get into federal court? And from the plaintiff's perspective, the answer is an obvious yes. There is emergency assistance being distributed right now. They are not getting that, and that feels like an injury to them. From the government's perspective, because this is a tax credit at bottom, and it's just an advancement of that tax credit this year, there is no injury until after the 2021 tax filing season. And so there's kind of special treatment for this, in the government's view at least, for this injury because it's part of a tax distribution scheme. So far, no court has agreed with the government, and each one has allowed the plaintiff's claims to go forward on the theory that I just articulated. Then there's also this issue, again, which Les flagged, of whether the plaintiffs need to wait until after the 2021 tax filing season to file a refund action. And this is closely related to the issue of sovereign immunity. So I'll kind of put a pin on this and return to it in the next slide. And then go back slide. I will get to it in the next slide. Then the third issue that cuts across each case is whether there is, in fact, an alienage classification, or what's also referred to as a classification based on immigration status. And the government has taken the position that this has nothing to do with undocumented status, and certainly nothing to do with punishing people for who they marry or who their parents are, but instead it's about making sure that people have social security numbers and that they're authorized to work. Those two things are a little bit difficult to disentangle if you look at the statute, because who is eligible for a social security number is defined in part by whether you are a citizen or what your immigration status is. And then also, just from a practical standpoint, given recent events, the affected populations very much feel like they are being targeted and unfairly denied these benefits. And so there's a motive in those communities to push back and assert what they view as their rights. There are a couple of additional issues in the spouse cases that are not in the case that Les and I are working on, which relate to, of course, the specific merits claims in those cases, and also something called the first to file rule, which I did not mention, but each one of these cases is a class action. And it's worth bearing in mind, if you're bringing a class action, to check whether somebody else has gotten there first. When that happens, courts have discretion to hit pause on the later filed case or even dismiss it. So you can end up doing a lot of work up front and not getting to see it pay off if you don't make that check. There have been decisions in 3 cases, the RV case on behalf of children, and then 2 of the spouse cases. In the RV case, as I mentioned, the court allowed the claim to go forward, found standing, found no issue with sovereign immunity, and that's true of all 3 cases, those first 2 holdings. And then the court also found that the plaintiffs had stated a claim on the merits that the children had been discriminated against, and found, at least at this stage of the litigation, that there was no rational basis for the exclusion of even that $500 portion of payments based on parents' immigration status. And in the spousal cases, there was actually a split decision. One said it can go forward and one dismissed it. So next slide, please. Okay, and I'll try and run through this quickly because I'm coming up against my time. But in any case, when you file against the government or a government official, you're going to have to contend with sovereign immunity, which is basically a principle that says you cannot sue the government unless they give you permission to do so. And that's normally taken care of in tax cases through tax-specific waivers. And so refund action, for example, which is what the government is saying the plaintiffs have to proceed through, there's a waiver for that. There's a waiver for deficiency proceedings as well. But because all these cases are trying to move forward now and not next year, they have to get a different route in. One route in is to say that the government official, and this is the one we pursued in RV, is violating the federal constitution. And there's a legal fiction that's applied there that says that if a government official is violating the federal constitution, then they are not actually acting on behalf of the sovereign. And so sovereign immunity is not a barrier. And then there's also a waiver in the APA, although different circuits have reached different conclusions on whether you need final agency action to invoke that waiver of sovereign immunity. But as a basic matter, if you're not claiming damages, you're probably going to be able to find a way into court. If you're claiming damages, things get a little more complicated, and you may be shut out entirely, or you may be forced to wait until the refund season begins, or the refund action season begins. But we have elected to try our claim under what's known as the Little Tucker Act, which is for small damages claims against the government. There's also a regular Tucker Act for bigger damages claims. And this is kind of a catch-all waiver of sovereign immunity that allows people to sue if the government violates a mandatory obligation to pay damages or other compensation to individuals. And there is no requirement in the statute that there be an explicit cause of action that comes through in the Tucker Act. And I think what's probably most interesting for this audience is the government argued that tax statutes are categorically barred, or tax claims are categorically barred from proceeding under the Little Tucker Act. And the court in RV rejected that. It was not the first court to do so, but there aren't many. So we'll see how that holds up, but I think it's an important lesson that this is potentially another way into court moving forward. And with that, I will pass it off.
Hi, everybody. I'm Jen. I'm one of the other non-tax attorneys on this panel who did not expect to be here last year, but I'm very happy to be included. Particularly because, as Nina was mentioning and Les talked a little bit earlier, as a public benefits attorney, I am very concerned and interested in the fact that I do think the IRS is going to become a bigger and bigger public benefits delivery system. So I think marrying these two areas of law is going to be really important going forward. But so while Rob talked a lot about a variety of litigation that really challenged eligibility under the CARES Act, I'm going to talk just briefly about the Magruder v. Mnuchin litigation that I brought with Les' book and a few other partners that really focused on challenging the delivery of that system. The difference being that nobody ever questioned at any point in our litigation whether our clients, which one of them, Mr. Magruder, is pictured in this slide, were eligible for these benefits. It was all about the process around which IRS decided to try to deliver these benefits. So Nina did a really good job giving an overview in the beginning, so I'm just going to touch on it briefly. But we were representing a variety of federal benefit recipients. This is important because if you go, can you next slide, please? If you go under the CARES Act, the CARES Act indicated that people would get these EIP payments, $1,200 for adults, $500 for qualifying children. The one kind of descriptive piece of information in the CARES Act about how it was delivered is it had to be delivered as rapidly as possible. And it was delivered rapidly as possible through tax infrastructure to a lot of taxpayers pretty automatically, pretty well. The problem is, as Nina noted, people who receive federal benefits frequently do not have to pay taxes. And when we're talking about people who receive federal benefits, in this case, the policy was specific to people who receive Social Security benefits, retirement, survivors, disability, SSI, which is a poverty program for people under the Social Security Act, veterans benefits, railroad retirement benefits. And what I want to say is common about all of these individuals, in addition to the fact that they typically do not pay taxes, is that most of them are either elderly or have a severe disability. Next slide, please. And as a result, we're dealing with a group of individuals which are going to be particularly challenged by the concept of extra tax forms, online forms, and all of that stuff. So while many EIPs went out automatically, the IRS created a policy where adult EIP payments would go out automatically to federal benefits recipients because even though they don't pay taxes, they do get monthly benefits from the government. So they are known to the government, but that they'd have to use the non-filer portal in order to register their children to receive benefits. Now, just briefly, next slide, please. The Tax Advocate Service knows that people, particularly people who are older or have disabilities, are particularly unlikely to have access to internet or computers, and actually indicated and concluded in 2017 that any policy restricting access to only online tools would negatively affect these populations. I bring this up because the non-filers tool, as many of you know, is an online-only form. Not only is it online only, but it's not mobile enabled, so you can't complete it on your smartphone, even though more than 50% of internet traffic is on smartphones, and that's a common way that people get internet access. It involves a lot of fairly sophisticated tax concepts, AGI, you need to have your driver's license number, a lot of information that a lot of people don't have. But so this form came into being, but the policy we were really challenging was not the existence of the non-filer portal, it was the next policy decision, which is the IRS announced through a series of press releases that federal benefits recipients would have a very, very, very short window within which to register their dependents to get these emergency child economic impact payments that they urgently needed, or they could not get them unless they filed a tax return next year. And just, the first press release, which was on April 20th, said Social Security and Railroad Retirement Board recipients had until April 22nd at noon to complete their portal application. So less than 48 hours. This was announced via press release. And then on April 24th, they said SSI recipients and veterans benefits recipients had until May 5th, so just 10 days to complete that same form. As someone who spends a lot of time working with SSI recipients, I was immediately concerned that my clients would not be able to do this. And we started thinking about it. So next slide, please. So it was just a very, very, very quick timeline, but there was no individualized announcement to people that they even had to do this. And it was clear that the window did in fact close. If you go to the next slide, as of May 5th, on the portal, it indicated that people who receive these federal benefit recipients would not be able to use this portal to register for these emergency payments this year. Next slide, please. And I just want to indicate that, this policy decision really did cause harm. It's hard to know exactly how many people it harmed. The New America did research and estimated between 250,000 and 450,000 federal benefits recipients could not meet these timelines. Just talking to people since we started this litigation, we know that many, many people were not able to use the non-filers portal in time. Most of them is because they didn't even know about it. I mean, these were just press releases, so a lot of people just had no idea they had to use this thing called a non-filers portal. A lot of people who did know about it didn't have access to a computer or the internet, and I'd like to highlight that these deadlines were April and early May. So this is a time of year when very few, when all public institutions like libraries were closed. So if you didn't have access to these at home, you weren't going to be able to access them. And then there were additional unresolvable issues if you had missing information, needed IPIN numbers, that sort of thing, that prevented people from doing it. And our clients indicated to us that not getting this money made a huge difference to them. You know, some of our clients skipped meals because there was huge food increases in prices. And if you are living on federal benefits, you are already living very close to the margin. You know, this pandemic caused an economic shock that really, really is harmful. We have one client who just went without toilet paper for weeks because they couldn't afford it with the increased prices. And this emergency funding would have helped with that. So I'm going to turn it over to Les to talk about, you know, after we realized there's this problem, we needed to figure out what, if anything, we could do about it.
Yeah, thanks, Jen. And you know, I should mention that while we saw early on the problems this created for our clients, and Jen and I and you know, Christine Spidel and lawyers from Berger Montague who were working on thinking about whether we should bring an action and what kind of action we should bring to challenge what the IRS had done. From the IRS's perspective, you know, they had a lot on their plate, right? So it wasn't as if they were doing this to harm our clients. That wasn't their intention. They wanted to deliver the money, the $1,200, to as quickly as possible. And I think from their perspective, by setting these deadlines, it would have allowed for the delivery of those funds, but didn't allow our clients to enter the information necessary to receive the money for their dependents. So, you know, there was, you know, some context here, but having said that, it really created all kinds of issues, which led us to think about, you know, whether and to what extent we could use the courts and other sources of pressure to perhaps get the IRS to change its decision and allow for the delivery of money that was really needed. So next slide, please. We thought about, you know, the Administrative Procedure Act and some of these issues that Rob mentioned. You know, the APA allows for a person who suffers a wrong due to an agency action to get judicial review. There's a waiver of sovereign immunity, as Rob said. There's a split in the circuits as to whether that requires final agency action, and as well as you know, a consideration as to whether there's an adequacy of an alternative review. And some of those kind of latter issues kind of mesh together with some of the justiciability issues, procedural issues. But we felt that the APA, from a substantive matter, right, requires an agency to consider relevant factors. Otherwise, the actions that it takes are considered arbitrary and capricious. And there's a Supreme Court case called State Farm, which really requires the agency to consider important aspects of problem, and that can arise either in procedural or substantive challenges to agency action. So we definitely felt like that the APA allowed for the opportunity to consider whether, in fact, the IRS's decision was, in fact, arbitrary and capricious, especially given the challenges that our clients faced. Now, there was a question about whether the IRS action constituted final agency action. As many of you know, the guidance that the IRS has issued in this area has mainly been through frequently asked questions, not through the normal kind of traditional notice and comment process that accompanies regulations. And again, from the IRS's perspective, it was important to get information out quickly. But it was clear that these actions, these decisions, had a significant immediate impact on our clients. It was also clear that the IRS had made the decision and publicly announced that this was really the means in which they were going to deliver that information to the public. And so we felt that clearly the IRS decision which would have required our clients to file a return in the 2021 calendar year for the 2020 tax year, would have been inconsistent with Congress's desire to get benefits out as rapidly as possible. So next slide, please. We thought about as well, in addition to the Administrative Procedure Act considerations, constitutional issues, and there is a really kind of robust body of case law that talks about procedural due process in other non-tax benefits areas that looks to ensure that individuals, before they are deprived of a benefit or a property interest which they have, requires there to be sufficient notice that is reasonably designed to inform individuals of the deprivation. And there is for the most part, the tax system has largely kind of relied not on constitutional protections or norms for notice requirements. There are statutory requirements embedded in Title 26, which have largely been kind of the way in which the IRS is able to ensure that individuals and other taxpayers are informed of IRS actions. So the issue that we confronted was whether, in fact, we could inject some of these procedural due process norms to evaluate the adequacy of what the IRS did with respect to informing or really failing to inform our clients and similarly situated clients about the very short and very difficult to meet deadlines. And as Jen and Nina noted initially, as more and more benefits are being administered through the tax code, and as Congress is contemplating another round of pandemic benefits that the IRS may have at its doorstep, these issues are really quite significant. Next slide, please. So we felt like that and as Rob kind of flagged in our characterization of what 6428 and the EIP is that the statutory structure of the CARES legislation created a property right that vested as of the time that the legislation was enacted. And that is supported by the language of the CARES Act, which required the IRS to deliver these benefits, that required, with a very limited exception, no IRS ability to offset against past due liabilities. And it's also interestingly consistent with what the government itself argued in the prior incarnation of the EIP, the economic stimulus payment that Congress passed following the Great Recession. So there was a lot of litigation around the nature of the advance payments that Congress delivered in 2008. There was a case called Smith that involved out of the Southern District of Indiana, and other cases like this as well. But the government itself argued in an amicus brief that the question there was whether the advance payment of the ESP, the 6428 credit, was property of a debtor as of the petition date that the bankruptcy petition was filed. There was no dispute that the stimulus payment was a property right. The question was, when. And the government and most courts that considered the issue agreed that the property right arose as of the time of the enactment of the legislation. And I think actually the CARES legislation is actually more favorable in this regard. Next slide, please, because there's no requirement to even file a tax return. The benefit is available, was available to all, and Congress directed that the IRS deliver those payments, as rapidly as possible. So we felt that all of this created the atmosphere and the legal context for arguing that procedural due process protection should apply, and we should look at what the IRS did in terms of its notification or failure to notify through the procedural due process prism, which has largely been absent from tax system. In the interest of time, I'm going to skip the equal protection argument that we brought in. Again, Rob mentioned the equal protection claim that was brought in some of the other cases. In addition, and I'll turn it back to Jen again, because part of this litigation involved not just the actual cause of the complaint that we filed, but a broader approach to bring pressure and attention to what was going on.
Thanks, Les. Okay, in the interest of time, I will be brief, but there's two other aspects of this project that I want to highlight. One is because of the time-sensitive nature of this case, us understanding that if we can't get relief before December 31st, 2020, this may not be really effective or useful. The litigation was only part of our strategy. From the beginning, we were lobbying with other folks, including the Center for Taxpayer Rights, New America, some other advocacy groups. We had ongoing lobbying efforts going on with senators and congresspeople and other decision makers, trying to get them to change this policy, this very short timeline after which they were blocking federal benefits recipients from, registering their children for EIP benefits. But as part of that strategy, we also had a media strategy the whole time. Now, the media strategy was kind of two-pronged. It was to both pressure add pressure in our lobbying advocacy as well as in the litigation advocacy. And we had some success getting articles about our clients placed in the Washington Post. There were 3 of them. But also, I know Professor Spidel worked very hard to get a lot of articles placed in Bloomberg and Tax Notes. With the help of many other people on this panel, in order to make sure that, those publications that decision makers explaining our theory and the story and highlighting the issue, we had the benefit of this case of having children who were absolutely eligible for these EIP payments and who are the children of people who get federal benefits being excluded. It's a very sympathetic group. So we knew it was a story we wanted to highlight. Next slide, please. We didn't bring a class action, and I think the next presenter will talk more about class considerations. But I did want to highlight that we did include an organizational plaintiff as one of our plaintiffs. And we did that for a few reasons. The main one being, when we decided that we didn't want to bring a class action, we knew we needed to have some plaintiffs in the mix that the IRS couldn't simply hand $500 to go away, right? We wanted to make sure our plaintiffs couldn't be mooted. And I just, one of the benefits of having an organization who works with people who are harmed is that if you include them, they can represent people who are not identified and cannot easily be mooted out. And so with that, thank you for, listening to us talk about this case. I will say that we are happy, please, just briefly, that on August 4th, IRS changed the policy. They reopened the portal, and the portal was reopened to federal benefits non-filers until yesterday, September 30th. They issued new guidance. There was an outreach plan. So in general, everybody, we did get most of the relief we were seeking, though strangely our plaintiffs have still not received their complete benefits, but we're working on that one. Thank you all.
Yaman.
Good morning. Thank you so much. I'm very happy to be here today. I'm a partner at the Leif Cabraser firm, and I'm going to talk about a case that we filed in the Northern District of California with our co-counsel, Justice Society, on behalf of incarcerated individuals. As many know, in early May of this year, the IRS published an FAQ on its website stating that incarcerated individuals, as defined in another provision of the Social Security Act, would be deemed ineligible to receive a economic impact payment under the CARES Act. They didn't offer any sort of explanation for this decision, no citation to legal authority, no formal notice, no rulemaking, none of the stuff that you'd expect to happen when an agency decides to take away a right from a bunch of people. If you could please move to the next slide. So what does the statute say? The statute doesn't say anything. It does not exclude incarcerated people. As most folks have already seen, the definition of eligible individuals in the statute is very broad, and that coincides with the purpose of the act, which was to provide economic assistance to people during this crisis on a very widespread and inclusive basis. Next slide, please. Okay. Who is the class in this case? So how big of a deal is it? There are over 1.5 million people incarcerated in the United States. We have a decades-old mass incarceration problem in the country. And incarcerated people and their families are amongst the lowest income and most vulnerable in the United States. So if you take the $1,200 kind of default line of a benefit, you're talking about potentially over $1.5 billion in payments that have been withheld from this population. Next slide, please. Okay. How did it happen? We actually have a very helpful Takedown report that lays out what was going on behind the scenes, which we relied on as we were investigating the issue and explained in our complaint and litigation papers to show what was going on. So in one of the early disbursements, the IRS, in fact, included incarcerated people in the payment program. Over 84,000 payments were sent out to people, presumably those who had filed 2019 or 2018 tax returns, totaling about $100 million. Once they were asked about that by TIGTA, the IRS said that they did not understand the statute to exclude incarcerated individuals based on their status as such. Yet, for reasons we don't know, or that were not stated at the time at least, the IRS subsequently changed its mind and then undertook a program to undo what it had done. Next slide, please. So we have some press reporting on this, and we have some other confirmation from the IRS. One of the steps that the IRS took was that it started contacting state correctional facilities around the country and asking them to intercept and return those payments. You saw the FAQ that was on an earlier slide, which also directed people who had received payments to return them, also including people who filed joint tax returns where one spouse was incarcerated but the other was not. Those couples were instructed to return the portion of the payment that was attributable to the incarcerated spouse. We have a quote in the AP story from an IRS spokesman who stated that he couldn't give the legal basis for that decision. So we can move on to the next slide. So summarizing what I had just said, the IRS took affirmative action when it published the FAQ. It assisted federal and state prison officials with returning the payments. It directed the state correctional departments to intercept them and return them. And then it implemented on the back end steps to cross-check a database that it has for other purposes that identifies the social security number or tax identification number of every person who is incarcerated at the state or federal level, to exclude those people from what it calls the payment files that were being handled by the Bureau of Fiscal Service. Next slide. Okay, why does this matter and why does it hurt? So the whole point of the Act is to help people now. And there's a broad misconception that the needs of people in prison are handled by the states. They've got housing, they've got food, they've got medicine, all that's covered. Turns out that that's false. What states provide is insufficient to meet many of the basic food and hygiene needs of people in prisons. So many incarcerated people actually rely on funds that are given to them by friends and family on the outside, or on the very meager income that they make performing prison jobs to supplement their needs, to buy food from the commissary. There's a huge industry that thrives on selling food, goods, clothing, and communication services to people who are incarcerated. And incarcerated people spend an average of about $1,000 a year on those necessities. And the friends and family on the outside, who are those also hardest hit by the economic crisis, are spending nearly $3 billion a year to support those individuals in prison. So it's especially problematic now because many prisons, because of the COVID-19 related lockdowns, have eliminated or curtailed in-person visitation. So even the ability of people to communicate with their loved ones on the inside is vastly diminished. And so how do those phone calls get made when they're available? It's very costly. There are private companies that are profiting off of this. The average cost of a call in California, for example, is $5.70. When you cross that with the fact that most incarcerated individuals have very low means or don't have much access to means, and their family members on the outside who have to cover the cost of a collect call, for example, are also disproportionately low income, that compounds the problem here. And so you've got incarcerated people being unable to maintain relationships, which contributes to a sense of isolation and diminishes their ability to succeed upon reentry to society. So we got support for, maybe I should backtrack a bit. So we filed our complaint and we filed a motion for a preliminary injunction. And as most folks know, to succeed on that, you've got to make a showing of irreparable harm, so delay equals harm, and that it's in the public interest to order the relief requested rather than wait until final relief. And so we had a submission from the San Francisco District Attorney supporting this request, mostly emphasizing the need of the hundreds of thousands of people who are continuously being released into society because their terms are up during the pandemic, into an economy where they can't find jobs, they don't have much assistance, and it's even securing housing is a struggle. Next slide. Okay, so we have 3 causes of action. The 2 I'm going to talk about here are familiar. They're under the Administrative Protection Act, Procedure Act. And so those are under 706 subsection 1, agency action unlawfully withheld and unreasonably delayed, and agency action which is contrary to law and arbitrary and capricious. We also alleged a Little Tucker Act claim, but we didn't include that claim in our motion for preliminary injunction. Just last Thursday, we had a great order from the district court granting our motion for preliminary injunction and certifying a class of all persons incarcerated in the United States in state or federal facilities at any point in time from the passage of the CARES Act, and also those who met the statutory criteria for CARES Act payment. And so that order actually orders the IRS to stop withholding advanced refunds from class members on the basis of their incarcerated status, and to redetermine the eligibility of any person in the class within 30 days of the order, and to make the payments promptly thereafter if they are deemed eligible at that point. It also requires the IRS to fix the language on its website which suggests that incarcerated people are ineligible, and to communicate the change in policy to correctional facilities. So one of the things that I learned during this litigation is that actually correctional facilities, in collaboration with the IRS, closely monitor any tax-related correspondence that is coming into or leaving prisons as part of an anti-fraud program. And so that coordination is important to make sure that folks can get the relief that they need, and the correctional facilities know that it is okay to deliver those checks if they're received in the mail to people who are incarcerated. As was mentioned earlier, the IRS has established that October 15th timeline, and given that they have represented to the public that incarcerated people are ineligible for almost 6 months now, we filed a motion on Monday asking the court to order emergency notice to be provided to class members by the defendants, advising them of their ability to seek benefits if they meet the statutory criteria, notwithstanding the fact that they are incarcerated, and also asking that the IRS extend that deadline to file claims. In the 5 days since that order was published, we have received hundreds of inquiries from people with all sorts of questions. And really going back to one of the things that Jen mentioned, as the IRS becomes tasked with sending out public benefits, and the needs of different segments of the population are not fully considered in setting up the process, I think that's going to become more and more of a problem, and it's going to highlight the need for very user-friendly processes, particularly here where the non-filer portal is being called an abbreviated tax return, but for all intents and purposes, the only information that one is transmitting to the IRS is name, address, social security number. For the paper version of that form, the IRS is instructing people to put in 1110 in the sort of the income-related steps of the Form 1040. So people are very confused. Obviously, people in prisons have no or very limited access to the internet and then ability to file through the online filer portal. And so we're dealing with those issues now. What did the IRS say through all this? So in terms of legal arguments, they made many of the same arguments that were raised in the RV case and have been alluded to by other speakers, and the court here relied heavily on the RV v. Mnuchin case in rejecting all of those claims. But factually, the IRS admitted that it deemed people who were incarcerated as of April 30th, 2020 to be ineligible for advance payments, although it took the position that come 2021, when 2020 tax returns are filed, it would treat people who were incarcerated for less than the full tax year of 2020 to be eligible for a future tax credit. Next slide, please. So I won't go over again the same things that were discussed by others, except to highlight that this interpretation is really narrowly focused on kind of traditional tax issues, neglecting the fact that although this statute uses the tax infrastructure, it is different in kind, and it is meant to be a public benefit and an immediate cash payment first and foremost, kind of built atop the fiction of a future tax credit. The purpose of the statute at the end of the day is not to provide future relief, but to provide immediate relief. Next slide, please. I think that's it for my section, so I'll hand that back to Amy.
Yeah, so I think Nina want to make just a couple closing remarks, and then we'll be done. Thank you, guys.
Okay, thank you all. I think this was such a fascinating panel, and I just wanted to add something. As we've listened to folks talk about the three different cases, I think what I kept coming back to was Marty Ginsburg's tale when he was given the Distinguished Service Award, and he talked about the Moritz case and the environment in which Justice Ginsburg and Marty thought about taking this case. The perceived wisdom at that time was that the tax code was, quote, immune from constitutional attack. And where are we today? We have seen several instances of the courts saying something very different. And I think what these cases sort of bring to us is the ability to look at the tax system through different lenses and also to really come to grips with something that has been occurring in the code since the early 70s, which is the use of the code to deliver payments to people that are not directly related to taxation, your normal concept of taxation. So I just really wanted to say we just need to keep our minds open, and falling back on perceived wisdoms may not serve us going forward. Thanks, Amy.
All right, thank you, everybody. Thank you to all the panelists and to the ABA Pro Bono and Tax Clinics Committee for having us.
So yeah, obviously so much to chew on from that, but I want to make sure we give Chief Special Trial Judge Carluzzo plenty of time to also talk about all the stuff that's going on in the tax court as well. So with that, I'm going to go ahead and hand it off. Our second panel today is an update from the U.S. Tax Court, moderated by Tamara Borland. Tamara, you may proceed with the panel.
All right, thank you. As Caleb said, we're going to start by talking about updates in the U.S. Tax Court with Chief Special Trial Judge Louis Carluzzo, and of course there's been so much new and so much to talk about that's going on, so let's just launch right into it.
All right. Thank you, Tamara, and thank you to the ABA for inviting me to participate in this presentation. Looking at the clock, let me just sum up. Let me just we'll start with the description of the program and in the program dealing with tax court operations, and I will just say very quickly, the tax court is fully operational, and it has been throughout the pandemic, but for the hiccup where we had to cancel our spring trial sessions in order to adjust, things are proceeding in an order that allows the court to fulfill its mission. If you look at our website and you look at our orders being issued and our opinions being released, you'll see there's been virtually no change between what has happened before the pandemic and currently. With respect to reopening, I'll just quickly say we have never been closed, even though, again, the proceedings in the spring were canceled. And even though our main building in Washington, D.C. is not open to the public, the court is certainly open. So there's no need for really getting too much into a reopening discussion. Settlement days, we're going to talk about a little bit when I make reference to some of the suggestions that came in the grant applications or the participation applications. And I would expect that you folks probably have more information on that than I do, so I'd be happy to hear from you on that. And Zoom trials, I will say, again, hopefully we'll have some dialogue on that, and I am going to go a little quicker than I planned because I do want to hear from you folks. Had I had good sense, I would stop talking and open the floor to you folks to say what have been your experiences during our dozen or so remote trials that took place in September. But from our perspective, the judges do report, usually every Friday after the week is over. Those judges who had a remote session during that week are invited to make a presentation and give their impressions as to how things went and how things are going and how things are expected to go. And just generally speaking, I will say that the comments have been very positive. I have not yet had a remote trial, so I can't speak from experience. I have 3 coming up in October, 1 next week, and then 2 the following weeks. But I have had several motions hearings that we will talk about in a little bit. And in terms of efficiency, effectiveness, technology, things along those lines, the remote motion sessions have been going very well. And let me back up again, just things aren't quite the same. When I gave this presentation, and I'm not going to pretend that they are, but when I gave this presentation last time, I think I had noted that things just didn't seem the same because Nina wasn't involved. And so it's good to have Nina back, but even that, it's still things just don't seem the same. And I'm not going to, again, pretend that they are. When we were getting ready for the panel, there was some discussion earlier today about the different time zones that folks are in. Another thing that's not quite the same is our time slot for this presentation, which was routinely on a Saturday morning, in some years a little bit earlier than many people like. But that certainly became a little more civilized as the year went on. But my expectation is that space is rapidly losing its meaning, and so time probably is not too far to follow. With respect to the court's operations, let me return to some continuity, even though our circumstances are far different than last time. But I will give you very quickly just some of our statistics and the numbers in terms of court operations and what is going on. As of the end of August, which are the most recent statistics that we have published yet, as of the beginning of August, we had 21,759 cases pending. As of the end of August, we had 22,641 cases pending. Judge Holmes commented on this in his presentation. It's odd that the number of petitions filed during August was limited to 6, and I'm not sure if that was just an anomaly as a result of the way things are getting processed. If not, I expect that some of you will be receiving resumes from some of us looking for jobs in the near future. The split between regular cases and small tax cases has shifted in terms of the regular cases not subject to the small tax case election. Of those 22,641 cases, roughly 14,000 are not subject to the small tax case election. So it's roughly 2 to 1 not subject to the small tax case proceedings. And the percentages with respect to represented petitioners versus unrepresented petitioners very relevant to you folks, is remained fairly constant. 70% of our total population of cases involve unrepresented petitioners, and that breaks down to 60% in those cases not subject to the small tax case election, and 90% of the cases that are subject to the small tax case election. So overwhelmingly, the cases subject to that election are in need of representation.
Judge,
yes.
I just had a quick question for you, or maybe if you wouldn't mind a quick, I guess, plug for pretrial settlement efforts of LITCs and pro bono tax attorneys.
Well, I certainly wouldn't mind a plug, and I certainly, like all of my colleagues, we very much encourage it. I was going to talk about settlement days because there were a number of comments in the applications that address settlement days, but I'll skip ahead a little bit with respect to that. Some of the comments were very positive in terms of participation and self-represented folks taking the opportunity to engage with the IRS and the LITC folks who were available for their assistance. 2 or 3 of the settlement days apparently did not go well, with no one showing up other than the volunteers and the LITC folks. And so I don't know if that's a matter of communication. I don't know if that's a matter of geography. But one thing that is happening now, as a result of both the canceled trial sessions from the spring and the fall trial sessions that are coming up, is the judges are getting much more active in pretrial contacts with the litigants. Mm-hmm. And it is routine that in those pretrial contacts, usually by conference call, that settlement days, if they're available, are being noted if we know about it, and certainly contact with the LITCs that we do know about is encouraged. And that's a key. And again, maybe just to skip ahead a little bit, just to make a point that's obvious to all of us. The key to many of the issues that arise and continue to arise, whether in physical trials or now in remote proceedings, can be traced to the failure for the self-represented litigants to take advantage of the LITC programs early in the process rather than late in the process. And again, looking at the clock, and I'm going to skip ahead to some of the suggestions because it's directly on that point. I think it was from the Vermont folks. There was a suggestion, and there are various suggestions on how we could do it, but we do it as much as we can by stuffers, that's for sure. We are now doing it in conference calls in those cases where conference calls seem to be almost routinely being made. But a suggestion came in that perhaps placing a box on the petition that would allow the petitioner to consent to having the LITC reach out to the petitioner. For ethical reasons, for privacy concern reasons, those suggestions that either provide the LITCs with information so the LITC could reach out, good suggestions in order to get things moving, perhaps not so good suggestions when all the considerations such as ethics and privacy interests are concerned. However, this check the box suggestion where the petitioner, the litigant, is consenting to an attorney contacting the litigant with the offer of legal representation might do the trick, or I shouldn't go that far. It certainly is something to think about. And so if I can revert back to the manner in which we got the ball rolling for the limited scope appearances, limited entry of appearances, There were a lot of behind-the-scenes discussions when the ABA folks were ready, at least to make a proposal, not being under protocols, not being willing to submit that without an invitation to submit it. Maybe we should do the same thing in this context. Maybe you folks should caucus, come up with language that you think would work for a check the box, taking into account your ethical considerations, giving some deference to the court's well-publicized privacy interests, how we view the matter, and contact me. And when it reaches a point where we're satisfied it could move forward, if appropriate, then I'll discuss the matter. Actually, I'll discuss it even before it gets to that point with Judges Panuthos and Layden. And I know Judge Panuthos, at least I saw his name in the list. Normally he participates and he can throw me a lifeline when I go overboard. Unfortunately, I don't think he has the opportunity to do that. But I'll pass along that suggestion to Judge Panuthos and Judge Layden. And when it seems appropriate, then, and if it seems appropriate, then we would make that invitation for the solicitation. But that might be a wonderful way in order to get appropriate communications between the LITCs and the litigants well in advance of trial, well in advance of the settlement days, and well in advance of other deadlines that might come and go before you folks even get involved. So, and I'll move quickly because, again, we're pushing against it, and I do want to leave some time for questions. With respect to the limited scope applications, because of the way they're being tracked, there was a central reporting system that was in place early on when we started, where the numbers could easily be accumulated and then disclosed. That's no longer the case. So I can't give you updates on how many instances. But you all know that we've expanded the time when the limited scope entry of appearance can be filed. And I'm sure you all know that it's now under the Forms tab of our website. I don't think it's fillable, but it's easily convertible to a fillable PDF and then submitted in that manner. And again, leading around, and I apologize for skipping around, but a number of the suggestions talked about easier access of our website and making it more smartphone friendly because of clientele who are more likely to have smartphones than computers. That's already happened. Our website is certainly more friendly, and it is more friendly for smartphone devices. And I think you'll soon find that our our e-filing system will similarly be much more friendly for other than just a laptop or computer devices.
Judge, we do have a question in the chat. John had asked, would the tax court consider advertising scheduled settlement day events through its website?
I think we would consider any suggestion that comes in. I think we have considered that. And I'm not sure how far along these considerations went and what the concerns might be in terms of our presentation of something that we are not involved in, quite frankly. All right. With respect to, again, going back to early involvement in proceedings and the benefits of that, I want to talk just a minute about our remote subpoena hearings. Our subpoena process has been the topic of this presentation in past years and many other presentations in many other contexts recently, in terms of how the parties are hamstrung by the practice in the court in terms of how our subpoena process works and the limiting language, at least the way it's interpreted by the court in Section 7456 involving when trial subpoenas are returnable. We now have a system in place that allows a party who wishes to issue a subpoena to to ask for a remote hearing for a return date. I've presided over several of those over the past month. They are working well. They do not resolve the problem with a recalcitrant or a subpoenaed party who just does not want to participate or play. That would have to come up in a motion to enforce the subpoena. But what is happening is the subpoenas are getting complied with in many instances early, and that might have happened even under our traditional approach, when the subpoena issuer also includes with that subpoena a letter suggesting that if there is a response before the return date, then the subpoenaed party is excused from further appearing or appearing at the trial session. And that seems to be happening pretty regularly. The hearings get scheduled. We get a status report that the subpoena has been complied with, and we cancel the hearing. And oftentimes we're getting reports that there's been no compliance with respect to the issued subpoena. We can't do anything about that during these scheduled hearings, but what it does is it advances notice to the parties that further steps are going to have to be taken, and it advances notice to the judge who's assigned to the case that there's going to be or potentially advance or additional steps to be taken with respect to compliance in advance of the trial. And so in that respect, the proceedings are working well. They're only set through November 3rd. We only set them for the fall trial sessions, taking into account the period when e-filing will not be accessible. I expect that we will continue them for the fall. There was a question in the applications, suggestions to publicize earlier our trial sessions. I will tell you that our winter trial sessions will soon be released, and so that information should be coming out. And although it is not formal and there's been no formal announcement, I would fully expect that the winter trial sessions are going to be conducted remotely as well. With respect to, and again, I'll circle back to the limited entry of appearances. When that proposal first came in, there was a suggestion or a proposal that it be limited not only as to time, but as to function. And that proposal has been repeated in some of the suggestions in the applications for participation. And I will tell you that the process is a work in process. So what is currently in place is not necessarily what's going to be in place in perpetuity. The thought process was, when we limited it to just time, that we would start with baby steps. Not because we're all babies, although some of us might have that reputation, but because it was entirely a new thing, and it was needed. And again, kudos to you folks for getting the ball rolling and then making it happen. It will be under review, just like it was changed now for the remote hearings, and I expect it will be under review and changed as circumstances present themselves or allow for it. So I'm already over, and I do want to leave a little bit of time if I can. If not, I'll defer, but if there are any questions, I'm happy to take them.
Yeah, we do have a little bit of time for questions. If folks have them, please put it in the chat box. As I'm giving folks an opportunity to type, I did want to pass along a message from the Chief Counsel Settlement Cadre. Chief Counsel Settlement Cadre really wanted to recognize the efforts of the LITCs and the pro bono attorneys that have been making the pretrial settlement remote days a success. Y'all have been able to settle hundreds of cases across the country, and from what I've been hearing, on the whole, these remote settlement trial settlement days have been pretrial settlement days have been pretty successful. So they just asked me to pass that along.
Well, you can never get too many pats on the back. Although I'm sure that at some point that it almost becomes rhetorical. But certainly the involvement of the LITCs cannot be overstated by those of us involved in the process. And I made this comment a while ago. Normally at this time we would be talking about our December, your grant conference, and what a date's going to be, seeing you all then, and perhaps struggling over a date for the dinner. I'm not sure what's going to happen this year.
Yeah.
But we're not going to have the opportunity to thank you at the dinner. Certainly thank all you folks now. But I made this observation, and I'll make it again. Early in the process, many years ago, it was unusual when we had a clinician involved in a tax court trial, and we were so grateful for that. It's so much easier when you have a representation on both sides. Easier for the judges, better for the system. Now, to me, it's routine. And I almost am no more thankful to the LITC folks than I am to the IRS attorneys. Quite frankly, I expect the LITC folks when I show up at a trial session, whether it's going to be remotely or hopefully soon in physical trials. But that's not to suggest that there's not gratitude there. You just might not get thanked by me as often as you did 10 years ago. But anyway, thank you for putting that out, Tamara.
Yeah, and I have a question. Christine Spidell is asking about how the virtual trial sessions are going. We know that you haven't had a trial as yet, but how have the calendar calls been going from your perspective?
From as best as I can tell from the comments from others, it has gone very, very smoothly, both in terms of the technology, although there's been a couple hiccups with the audio feeds, and I'm going to divert a bit. Again, something I was going to comment on in a more structured presentation. The decision not to allow your law students into the presentation, the decision only to allow the law students to participate by audio, it probably also will be under constant consideration, just to see how that is working out. And I think that might vary from calendar to calendar depending upon the presiding judge. So if you do have some students that you would prefer to be involved in the presentation, not just by audio, it might not be a bad idea to ask for a conference call with the judge to see what the judge's take is on that. And I'll probably get some pushback from some of the judges on that point. But I do think some of the judges might allow it, depending upon the numbers that are involved. But I understand why we did not allow it in the early stages, just to ensure that those who needed to be in the courtroom got the proper attention. I'll get back to the point. There's been some hiccups with respect to the audio feeds in terms of what is believed to be the bandwidth of the various, where some of the proceedings are emanating from. I have heard no negative comments with respect to the actual trials that are taking place in terms of folks losing connections, being disconnected and not being able to rejoin, in terms of awkwardness of the presentation, in terms of awkwardness in the examination of the witnesses, in terms of time and or even other logistical problems that might come up in real time, sharing of documents, introduction of evidence. All the comments that have been coming in have been coming in smoothly. With respect to, I think, one of the trials, and although I don't know we knew the reason, but speculating that the litigant who was represented by an attorney might not have had the technology to participate, joined the proceedings at the facility of the attorney on separate devices. And that apparently doesn't work because of the technology. If they're in the same location, apparently it works better with one device. And so that, I think the adjustment there was then both the litigant and the attorney started sharing the same device. And if any of you folks were involved in that, please let me know, and I'd like to hear it from your end. But that's about the only technology issue that I heard about. From the motion sessions that I have been presiding over, those have been gone as smoothly as can be expected. The calendar calls for that, however, are not representative of trial session. There's much fewer cases.
Yeah, so Judge Panuthos shared, I permitted students in New York and San Francisco without a problem. And then I have another question. Do you expect that the court will continue to require stipulations of fact and exhibits to be filed 2 weeks before trial?
I would expect that as long as the remote proceedings seem to be the course of action. It's not a bad practice even for a physical trial, quite frankly. With respect to proposed exhibits, I'm not sure. Again, if we had time, I'd like to hear from the attorneys on that. How do they feel about essentially emptying their briefcase before they get into the courtroom? I'm not sure how the judges feel about looking into an attorney's briefcase before the attorney is into the courtroom. It's one thing to stipulate. It's another thing to actually have filed a document that might never be either introduced or I should say either offered or introduced, to have that in the record now. So I don't know about that practice. And many of the things that we're doing, I think, go into the category of any port in a storm. And I think, and not only in our court, but I'm hearing from other courts, that we recognize that this is an alternative to live trials, person-to-person trials. I don't know that many of us, or I don't know how many folks believe it to be a substitute for in-person trials. But the stipulation process, our rules contemplate that now. Our rules provide, 91 says you can file a stipulation before trial, and once it's filed, you don't even have to offer it into evidence to have it taken into account. So that practice has been long-standing, and I would expect it would continue. The submission of proposed trial exhibits, I would say, stay tuned. Also, stay tuned for a press release dealing with procedures during the period when our e-access system is down. Okay.
So I think that is, at least for right now, all the questions we had in our chat.
Well, I appreciate the time. I sincerely apologize for going over. I'm not going to take the full blame. I also apologize for not proceeding in the manner that I had originally intended, but from jumping around from topic to topic. But I did want to get some of the higher points addressed. But anyway.
And I apologize for maybe jumping in and getting.
No. Getting back to the check the box on the petition, I should also say, in years past, our form petitions, because of our e-filing system and because of our system now, another soon to be pay attention, e-filing of petitions is coming along. When that happens, I think it will be easier to change our forms to electronically when space is not so much a consideration on paper. But again, stay tuned for that. But on the check the box, if you folks come up with a proposal, please let me know. My email, stjudge.carluzzo@ustaxcourt.gov, and we'll get the ball rolling. And again, I don't see why it could not proceed along the same lines that we were able to make progress on the limit entry of appearances. So
I'm sure the committee is forming as we speak.
All right. Well, thank you very, very much, Tamara. Thank you. And let me thank Megan for holding my hand remotely in terms of how to even deal with this system. And good luck to everyone. And can't wait to see you all on other than just electronic images on a video screen. So.
All right. So I'm going to be very brief with some closing remarks. I know the panelists have generally apologized for going slightly beyond their allotted time, but honestly, this could have gone on much, much longer. There's so much information and so much things changing, and I found it extremely informative. I know one takeaway for myself, beyond just always appreciating how receptive the tax court is in working to make sure that pro se petitioners, are linked up with attorneys. One other takeaway I've had is kind of a reminder to step outside the tax silo when you can. That was from the first presentation to me. There's so much we can learn sometimes from other areas of law. I know I'm sometimes guilty thinking just in terms of Title 26. There's so many other titles out there. And kind of on that similar note of just how much more information there is out there and how much more we could have gone into detail on these, I want to make everyone aware of this new thing that our committee is doing. It's the first one. I'm calling them Fireside Chats because it's sweater weather out there right now. And the idea is really it's going to be something, most likely a Zoom webinar style thing, except for not CLE, that has speakers on topics of the day that they've experienced with, so as a resource, but also responsive and a little less formal than a CLE, so that we can address things like, well, some people have gone through virtual trials. What are some best practices there? Some people have gone through calendar calls. What are some best practices there? There's so many issues to cover, and so we're planning on doing those monthly. The goal is to be, responsive, flexible, responsive to the community. So for issues that you all out there are seeing and you'd like addressed, and it can be, how to, better integrate with other areas of the law of bankruptcy, other things like that, it's totally fine. Send those Sarah and my way so we can put them in a queue for potential, again, I'm calling them Fireside Chats until somebody comes up with a different title, so that we can put them on, our list. So look for an email to the listserv about which ones are coming up. And then, as always, you can reach out to Sarah and myself. Sarah, do you have any other closing comments?
I just want to thank all the panelists for a wonderful morning. Nina, Judge Carluzzo, and all the talented litigators for achieving justice for low-income taxpayers. That's what we're all about. Also want to give a big shout out to Meg, who did a superb job of corralling all of us and making this happen. So on behalf of the American Bar Association and the ABA section of taxation, thank you for participating in today's program.